A Super TPD insurance, or a total and permanent disability claim, is a lump sum benefit that's associated with most people's superannuation funds. So most funds will offer members a default or an automatic TPD benefit, and these benefits can range from a relatively modest few $1,000s up to $1 million or more. The amount of the TPD will be reflective of the premium that's being charged for them. Most people, or often people, won't be conscious of the amount they're paying because the premiums for the TPD will come out of their superannuation fund or their contributions for superannuation as they go in on a regular basis from their salary. Members can choose to increase the amount of their TPD benefit or indeed take out their own additional TPD benefits if they don't feel that their current fund adequately insures them for the risk of a total and permanent disability. In terms of the claiming of a TPD, every fund will have a different waiting period and will have a different what we call definition. In most cases, the average waiting period is approximately 6 months. So what this means is that from the time of your injury, you would have to be considered incapable of returning to that work for a period of at least 3 months. And again, that period could be longer for some funds, or indeed could be shorter. It might be as short as 3 months. But this means a total incapacity. So we're talking about a complete inability to return to your job that you're employed to prior to the injury for that sort of minimum period of time. Now, following that threshold, it would then be a matter of obtaining evidence from at least 2 doctors who consider that indeed you are permanently incapable of returning to that job. So that often will just be a form that the fund will provide, a pro forma form as we call it, so it'll have a set number of questions that the doctor, and generally it's 2 doctors, so often it might be your GP or your specialist, will need to complete. And that'll define the injury you have and the symptoms and the prognosis, but specifically will go to the fact that in those doctors' opinion you are unlikely to ever return to work, or at least the work that you were doing. The second major threshold is what we call the definition. So the definition, and the standard definition, is generally an inability to return to the work for which you have education, training and experience. So to use a really basic example, that might be a doctor who has suffered an injury. It might be an injury to his it might be a physical injury to his hands, for instance, that would prevent him from being able to return to surgery. Now, that wouldn't necessarily prevent him from, say, working in a call centre. However, clearly it would prevent him from returning to work within his education, training and experience. Now, those definitions, or the general definition, is extremely broad. That's a very broad definition, and so each fund might look at that slightly differently. Some may apply a more strict view, and others might look at it more broadly and effectively apply it in circumstances where a person's worked in an occupation for a fairly long period of time, i.e. years. They're clearly unable to return to that type of work, and the fund would, and in their view, that would satisfy that definition. A number of, I shouldn't say a number, but funds also might have a retraining definition. Again, there may be an obligation that the person has to undergo some form of retraining or an attempt to return to some form of retraining or work, again, in order to satisfy the definition. Now, all of these thresholds or definitions are going to be slightly different for each fund, and applied slightly differently. In terms of actually making the claim, the starting point is to the fund itself. The fund will generally, as I said earlier, have a number of forms that they'll send out. Inherent in all of those will be to obtain forms signed by your doctors. Effectively, you provide those forms, and generally from there the fund will then start requesting further information from you, and in time will ultimately make a decision as to whether you satisfy their requirement or their definition for a TPD. On average, this process will take generally months, certainly not weeks. 6 to 12 months is not an unreasonable estimate, depending on how much information can be provided to the fund. In my view, for a lot of people, it is very sensible for them to seek legal advice and have a lawyer assist them in making the claim. The reasons for this are a few. Firstly, it's speed and time. As experienced lawyers in this area, we're aware of what the funds are seeking. So we can immediately obtain all of the information that they'll want, and that will include hospital records, GP records, ATO records, other financials, obviously the prerequisite forms to be completed, and any other supporting material. So we can obtain all of that relatively efficiently and quickly, put all of that material together and make some very general submissions, legal submissions around the particular definition. So we can mount the standard arguments in respect of what education and training and experience should mean and how that might be applied. We then will make those submissions, and then we'll follow up the fund consistently, frequently, in order to obtain a decision on the claim as soon as possible. So it's efficient, and it's going to cut down a lot of time and a lot of work for the applicant. If the claim is rejected, then part and parcel of having a solicitor acting for you or assisting you, they're going to be able to provide you advice on the reason why the claim was knocked back and whether it might be worth actually litigating that issue. And when we say litigating, we mean looking at the potential of court action, or looking to, in the first instance, the Ombudsman for a review of that decision, following that through, and then ultimately potentially a legal claim, a court action. And again, we have acted for people in such claims through the courts, and ultimately and generally those claims tend to settle in the court system prior to trial. That work again is all undertaken, the claim work and any potential litigation. For Johnston Withers, we undertake all that work on a no-win, no-fee basis. So there wouldn't be any fees involved at all until and unless the claim was accepted and there was a lump sum payment. The other reason to use a solicitor is generally because we're in a position to provide advice earlier on and preempt the type of evidence that might be quite specific to your claim. So for instance, we can write to specialists or send the claimant to a specialist in order to obtain particular medical evidence to support the claim, therefore preempt the issues that the insurer may have with the claim. So there are a couple of reasons why I would strongly recommend seeking legal opinion, or at least legal assistance and representation. Other than that, however, and I should also say, sorry, the other reason is because you may have other funds that you're unaware of. So we will look through all of the necessary paperwork you've accumulated over the years, right to all of the super funds that you've had, because there may be little bits of TPD cover that you've had during relative periods. So we've had claimants with up to 3 or 4 separate TPD claims, which we have all ultimately had success and had accepted, because the person's changed jobs, so they've accumulated a number of superannuation funds. Please obviously feel free to call Johnson Withers. We'll provide some free initial advice and assistance in order to get you started and commence on the process.